Okay, perfect. We are now officially on air and the recording has begun. On the first page, you are going to see, Tash, you should be able to see, in terms of audience view, the first page to the rules rule, okay? Tertius Maree is not someone that really needs much of an introduction. His name speaks volumes, as it is. But for those of you who might not be completely aware of who Tertius is and what it is he does, Tertius specializes in the legal aspects related to the management and administration of sectional title schemes. Since its establishment in 1981, the focus of Tertius Maree and Associates has gravitated towards sectional titles. Today, the firm is an acknowledged leader in the field of sectional titles and related property formats, specializing in the administration and management aspects of the law relating to sectional titles, homeowners associations, and retirement schemes. Tertius has also written a number of books and guides on sectional title, the latest being, which is also now available, the Pocket Rescue Kit for new trustees. So if you're a new trustee or you're thinking of becoming a trustee, I think it may be worth your while to contact Tertius's offices to find out a little bit more about that. But just welcome to everybody that has joined us. We've got an overwhelming response, as I mentioned earlier. We've got people from around the Cape, people that are joining us from Durban, PE, Johannesburg, Pretoria. We have trustees, we have managing agents, we have a few other attorneys and experts in the field, and I'm sure everyone is very, very interested to hear what Tertius has to share with us today. So not to keep anybody any further, without further ado, I'm going to hand you over to Tertius, who is now going to start his presentation on the rules rule okay. So Tertius, without further ado, over to you.
Thanks, Lisa. Okay. What I would like to talk to you about is actually how the rules must be seen as an instrument of administration and management in sectional title schemes. And as you see on the screen now, a scheme shall, as from the date of its establishment of the body corporate, be controlled and managed subject to the provisions of this Act by means of rules. This is what Section 35(1) of the Sectional Titles Act says. It means that the body corporate is not governed by simply by means of trustees' resolutions, even members' resolutions, chairman's edicts, or arbitrary dispensations. By that, I'm not saying that those resolutions are not important. They are very important, but this one, okay. It means that a matter can only be determined by means of a resolution when it's allowed by the Act or by the rules. In other words, there must first be a rule to allow trustees to make a particular decision. They can't just by making a resolution establish a situation where to which owners are bound. Rules may not be superseded by resolutions, even by unanimous resolutions. I've seen at general meetings that when the trustees are uncertain as to how to go about something, they say, okay, let's make a unanimous resolution and do this, build this or break that down. But that is not the way to go about. First of all, if there is not a rule in place that governs the particular thing that the trustees want to do, if there's no rule in place, a special rule must be made. It may be a conduct rule or a management rule, depending on the subject matter, but without a rule, they can't make that resolution. It also means, and there's been a question about house rules, it also means that there is no such thing as house rules, because Section 35 of the Act says that there are two types of rules, the management rules and the conduct rules. There is no third type of rules, and it's also not allowed for the members to make a rule, even a management rule, to say that trustees can make their own rules, they call it house rules or whatever you want to. You can't make a rule allowing the trustees to make rules, which they normally call house rules. There is no such thing. Also important is that the provisions of the Act and the rules are not mere guidelines, but actually it lays down the legal framework within which flexibility and discretion is allowed, and or allowed by implication, or specifically when additional flexibility or wider discretion is sought, the relevant rule must be amended appropriately or a special new rule must be made. Now, Section 38J of the Act I find particularly difficult to interpret. I've read up what Professor van der Merwe had to say about it, and he's also sort of shying away from exactly what it means. But the way it reads it says that the body corporate has the powers to do all things reasonably necessary for the enforcement of the rules and for the control, management, and administration of the common property. Now, the question arises, and this is what, well, Professor van der Merwe even says that allows the trustees to impose fines when you do not comply with the rules. I disagree with that, and there's a very good reason why I think it cannot be done, and that is because of another piece of legislation known as PAJA, the Promotion of Administrative Justice Act, which lays down certain constitutional guidelines as to how any such thing, any such administrative action, such as imposing fines, must be conducted. And it's quite complicated, but it amounts to, in simple terms, it amounts to the fact that the person that you want to fine must be given an opportunity to present his own case, to put the witnesses under cross-examination, etc. Now, the trustees can't fine a person for breaking the rules unless they follow those procedures, and to be able to follow the procedures, they must first make a rule that lays down those procedures. So the trustees cannot impose fines unless they have that rule to support them. Also, as far as 38J is concerned, one could say that it allows the trustees to do things which are ancillary to existing rules, but not to do something that actually requires a new rule. Now, an example of when a new rule is required is the enclosure of balconies. You will find no rule in the conduct rules or management rules that allows trustees to consent to the closure of balconies. And there's something that happens quite often. And we get it at our office very often. And to do that, you actually need to make a new rule. And there's a very comfortable place to include that, namely in Conduct Rule 4, which then only needs a special resolution in order to allow it to insert the rule, which will then give the trustees the power to consent to the enclosure of balconies and lay down the necessary conditions for that. It's very often regarded by trustees that the management rules and the conduct rules are mere guidelines. They are not. They are actually rules like law, and these rules have been the standard, the prescribed rules have been put in place by the legislature as a model for which actually relates to the typical sectional title scheme, which is a block of flats. Sectional titles has been developed, the sectional title legislation has been developed over the years actually for a block of flats. But of course, it turned out that it could be used much more widely than just for flats. Now, because of the fact that the legislature cannot be expected to provide a set of rules for every type of sectional title scheme that you can get, therefore the developer is allowed to put rules in place, and later on also the members. Now, the reason for that is, of course, what I'm referring to now is the diversity of scheme types, and it's quite amazing to see what kind of sectional title schemes you can get. It could be a block of flats, the typical model. It could be freestanding dwellings like a homeowner association. It could be retirement village, which could be a homeowner association or sectional title scheme. It could be shops, offices, factories, hotels, hospital, medical centers, holiday resorts, and I've even converted a caravan park to a sectional title scheme in the Southern Cape. It allows mixed-use schemes which are, for instance, partly residential and partly shops and offices. Now, these are, of course, immediately a problematic situation, because how do you present a set of rules that will serve all three of those elements or components of the scheme? Such diversity requires rules which are appropriate to the nature and needs of the particular scheme. Now, was that okay? The first set of rules, which are of course very important, because that's how the way the sectional title scheme starts off, is the rules made by the developer. And now the problem here is that the developer puts the rules in place, but it's usually drafted by the developer's conveyancer. Now, I don't want to incriminate my my colleagues in the field. I am a conveyancer myself. I have registered many schemes, and that's actually when I started specializing in sectional titles, when I saw that actually putting the rules in place is a much more responsible job than the actual conveyancing. Because, well, what happens in practice, of course, you're looking at the money. Now, a conveyancer at a large scheme with 100 units can make R500,000 out of the conveyancing. What does he make out of the drafting of the rules? Nothing. He will have to do that for free for the developer. Normally, he won't charge a fee for that because of what he makes out of the conveyancing. I'm guilty of that myself. That's how I started practicing sectional titles. So what happens is that the developer's conveyancer is not an expert on sectional titles or sectional title rules. He may take a set of rules out of his drawer or borrow it from another attorney, and it just puts that in place. Now, if it's a very complicated scheme, there are going to be problems. Those rules are not going to be suitable. That leaves the owners subsequently with great difficulty to have to amend their management rules with unanimous resolution and their conduct rules. And in fact, if there are many components in the scheme, which you often find these days in cities and large towns, the drafting of those rules is not an easy exercise. Now, what I want to point out is there's a misunderstanding that a body corporate comes into being at the inaugural meeting. That means the first general meeting of the members of the body corporate, and that the rules then start taking effect from that date. That is, of course, completely wrong. The body corporate comes into being when the first transfer is registered to the first owner away from the developer. And at that same time, the rules take effect. So from the first owner, the rules will be in place and they have to be applied. These will, of course, be the rules that the developer put in place. This is also a very important one. I have to explain that to trustees all the time. That, of course, one is tempted when you want to make a rule to follow the easy route, being the conduct rules, for which you only need a special resolution. One is very tempted to do that, but you can't. The integrity of the two sets of rules must be preserved. For instance, you cannot make a rule in the conduct rules relating to levies. Levies are being managed in terms of the management rules, management rule 37 and so forth and onwards. And if you want to put in any provision regarding levies as to, for instance, when they must be paid and when they will be regarded as being in arrear, you have to put that into the management rules. As difficult as it might be, you need a unanimous resolution and put it in the management rules. What is the only rule about levies which you can change with a special resolution? I'm asking that question. Somebody can answer me on that later. Now, the scope of the rules, who are bound by the rules? The rules are binding on the body corporate as an entity. It's binding on the individual owners, and it's binding on occupiers, the tenants. They're also binding on the trustees. They're not binding on visitors that come and visit you, but for that you need to inform them. The host needs to inform them about certain things, about such things as parking, etc. And of course, you can also put on signs where necessary. But if your visitors should transgress, then the owner himself will be held liable if necessary. The managing agent, is he bound by the rules? No, he's not. The managing agent is not mentioned in the Act or in the rules as being bound by the content of the rules. But of course, not even by the management rule that relates to managing agents. He's not even bound to that. He's only bound to the terms of his contract. But of course, a managing agent that disobeys or disregards the rules and will not be worth appointing as a managing agent, and that is for the trustees to check and make sure that the contract to start off with, the contract must make provision for the managing agent to be not only aware of the rules but to comply with the provisions of the rules. Amendment of the rules. The moment that the first transfer takes place and the body corporate comes into being, the developer can no longer amend the rules. Only the body corporate can do that. The amended rules take effect from the date of filing at the deeds office. Rules not filed cannot be enforced. So you can't have your meeting, your general meeting, and adopt certain rules and then apply it the next day. They must first be filed, and we must be able to prove that it's been filed. But must also take into account that in our present regime, call it that, where rules are filed at the deeds office, these rules are not registered, as is often said. They're not registered. They're only filed and kept in a filing cabinet. The rules are not examined by the deeds office examiners. So the fact that your rules have been filed at the deeds office is no guarantee that these rules are actually enforceable in the sense that they are legal. That will hopefully change when the Ombud Service takes over the responsibility of filing the rules, because they will have a set of examiners who will then check the rules for legality, and they will be probably rejected if they do not comply. This is something that is imminent, and we'll talk about that later. Limitations in rulemaking. Rules must be reasonable. They must be reasonable. They must apply equally to all owners of sections used for substantially the same purpose. But that means, of course, when you have a block of flats with shops and offices, then you could have separate rules for those three components. But they must be within each of the components. The rules must be reasonable and apply equally. Now, this is a difficult one. No rule made by the body corporate or the developer may be irreconcilable with management rules made by the legislature. In other words, the prescribed management rules. That's a very difficult one to understand and to comply with, because normally when the body corporate makes special management rules, you will deviate from what the prescribed management rules say. I don't know what the court will do about this, but in my view, this provision must not be interpreted too strictly, because that will limit the body corporate as to what they can do as far as rule changes are concerned. Once again, house rules. No rule may be made to authorize trustees, authorized rules to be made by the trustees. So that is the answer to the question that one of the attendees have given us about house rules. No, house rules are not enforceable They are not legal or enforceable. While we're on that, discontinuing services in order to enforce rules is not allowed. Even towing away, I'm mentioning that because if you look at the conduct rules, you'll see that one of the prescribed rules says that vehicles that are illegally parked can be towed away. Now, I would not recommend that trustees should ever do that, because they could face a spoliation order and be ordered to return that vehicle and also pay the cost of that, even though that rule is one made by the legislature. Let's talk about directives. We know that Section 39(1) allows the owners, the members of the body corporate, to issue directives to the trustees or impose limitations on what they may or may not do. Is the converse also true? Can the trustees issue directives to the owners? To a very limited extent, the answer is yes, and there's already a rule like that, Conduct Rule 21C, regarding refuse disposal. That does not mean that when such a directive is issued by the trustees that it actually becomes a rule, and that when when an owner is in breach of that directive, he is in breach of the rules. So the way to enforce that will be very difficult if the owners tend to breach such directives. Then it must be considered to actually amend and expand the rule itself in order to cover what the trustees want to be done. Similar directives may be issued by trustees regarding parking. Enforcement. We've spoken about enforcement in relation to Section 38J. Now, first of all, one must realize that arbitration is not a way to obtain enforcement, because an arbitrator is merely a judge that decides on the legality of certain actions or non-actions. Even the Ombuds Service cannot issue a directive or issue a what do you call it? An order that an owner must do something or not something, an interdict. A delinquent owner forfeits his voting rights at general meetings unless a carefully worded penalty provision has been incorporated in the rules. The normal remedy for breach of rules, for enforcement of the rules, would be to apply for an interdict at the court. One can also apply for interdicts at the magistrate's court, but depending on the amount involved or the value, one may have to apply to the High Court. Now, this of course is not an easy matter, and it's not something that trustees want to do. They do not really want to become involved in court actions, and so there should be other ways to enforce. And I would say that the imposition of fines, if you have a proper penalty provision in place. Now, that penalty provision must be very carefully drafted. It must make provision for notifying the owner, and for a hearing to which he must be invited, and also call witnesses and cross-examine witnesses, etc., and explaining his case and argue his case. The rule must make provision for that, and not only that, the trustees must then abide by these rules. They must follow these rules. They can't just issue fines because they now have the rule. They must follow the provisions of the rule. I'm saying this because I've seen it very often that trustees instruct me to provide them with a penalty rule, and once they have it, they just issue penalties left, right, and center. You can't do that. Now, non-payment of levies, not paying levies is, of course, a breach of the rules, but it's addressed differently to the breach of other rules. It is a breach of rules, but it's that the non-payer will have to pay interest if interest rate had been determined by the trustees at the time of issuing the levies, at the time of fixing the levies. Now I've got a big question mark there, and Graham Paddock will understand why I've got a question mark there, because under the new Act and the new regulations, that interest rate is going to be very limited, and this may or may not be a good thing. Our time for objecting to that has expired already, and we'll see what the regulations will say when it is actually finalized and published. And what Graham can also tell us is when does he think it will happen. I'll give my idea just now, but we don't know when it will happen. Then the non-complying owner that doesn't pay his levies will also be subject to levy collection procedures and the costs, the legal costs involved, which would include attorney and client costs, which is a cost at a higher scale than ordinary magistrates court costs. He will forfeit his voting rights. So once again, I've got the question mark there because in terms of the new regulations under the new Act, when it comes into operation, those voting rights will only be lost if if a judgment had actually been issued in respect of those arrear levies. In other words, an owner is not regarded to be in arrear unless there's a judgment against him for those arrear levies. I disagree with that because it actually forces the body corporate, the trustees, to take action, court action against the owner. Now, I deal with a lot of levy collections. I actually handle quite a lot of levy collections, and we find that it's very effective to deal with levy collections without issuing a summons, without taking judgment against a person and taking the court route. Of course, you can't have success with all of them. Sometimes you have to issue summons, but the majority of cases that we handle, we do it by personal contact, and it's very difficult for a debtor to say, no, I'm not going to pay if you speak to him personally. I find that works very effectively. But now, if this happens, and you want the non-payer to lose his voting rights, it means you are forced to take him to court and take judgment against him, which I don't think is such a good thing. The next one, I've also got a question mark, the acceleration condition. Now, I think not many bodies corporate are aware of this or apply this, but it's a very effective way of pardon? Well, it's a very effective way of consolidating your claim against the debtor. And I'll explain to you how it works. At the time when the trustees fix the levies at the beginning of the financial year or after the AGM, they fix the levies, there must be a trustees resolution. Now, there's nothing to say that levies must be paid monthly, but that's the normal way of doing it. Levies are paid monthly. But at the same time, the trustees can resolve that if the levies are in arrear, if levies ever fall in arrear and it's not paid within a certain time, then the whole year's levies become due and payable. That will be an acceleration condition as part of their resolution to fix the levies. That means at the time when he falls in arrear and is handed to an attorney, the attorney doesn't have to wait for the next month for another letter of demand, and every month after that another letter of demand. It actually makes it cheaper for the debtor himself also, because when it's handed to the attorney can make arrangements with the debtor to pay it off, but at least the debtor can't get away with the situation that he never pays his levies, and every time a new claim must be handed over to an attorney. It actually works very effectively. And then as far as arbitration is concerned, trustees must realize that arbitration is not the way to collect levies, except if the non-payer disputes the fact that he is responsible for those levies. Then there is a dispute, and that can be referred to arbitration. In other words, if it's handed to an attorney and that attorney receives a communication from the debtor to say he disputes whether the levies were apportioned correctly or whether there was a trustees resolution, etc., then it can be taken on arbitration. But arbitration is not the standard way that arrears are collected in the normal sense. Violability of the rules. Trustees must keep a record of the rules and ensure that amendments are filed at the deeds office. Now, I've got a question mark here. Copy of the current rules are always available at the deeds office. Why do I have a question mark there? It's because it's not really a reliable system. In the days when I visited the deeds office every single day, I saw that it's very easy for an attorney's clerk to go in and actually to, instead of having a copy of the rules made, just it takes all the rules out of the file, takes to the office and makes a copy there, and sometimes he forgets about bringing it back. There was no proper control over the rules at the deeds office. I believe the system has improved somewhat, and that is stamped, etc. Every page is stamped so that you can't put other pages in between what is there already, which is also something that was done. But it's a little bit better, but I hope that when the Ombud takes over this role of filing the levies, filing the rules, the system will be better controlled than it is at present. So, no, it's not reliable. You can't rely on it completely that when you go to the deeds office and you take out a set of rules there, that those are actually the rules. But that's the only thing you can in fact do. If you don't have a copy of the rules, you must find it at the deeds office. Now, PIA. Now, bodies corporate, I must just remind that they must have their PIA manuals filed with the department by the 31st of December. PIA is the Promotion of Access to Information Act. Now, whereas the sectional title rules make provision as to whom the rules must be made available, it is actually a much wider audience than what is mentioned in the rules, because PIA also bears on that. In terms of PIA, the rules must be made available to all interested parties, like a potential purchaser, etc., must be able to see the rules. PIA manuals must be filed before the 31st of December. If you have not done that yet, the trustees can contact Ilse at my office to assist with preparing those manuals and to have them filed timeously. I've still got some questions here, and they're not all that easy. And I'm glad that Graham is on the line, because some of these questions I will refer to him. Lizelle Kilburn is the first one. She's from STBB Attorneys. And the first question is, when in my estimation will the regulations be promulgated and the Act come into force? Well, the regulations have been submitted for comment, and the comments are all in and is being looked at the moment by none other than Professor Graham Paddock, and I think he's in a better position to give us an estimate as to when he thinks the Act will come into force. Can we? Okay, we'll just refer to Graham quickly.
Tertius, thanks so much so far for everything else. Lisa back online. Yeah, I'm just going to try and get hold of Graham. I just want to unmute your mic there quickly, Graham. Hold on a second just for me to sort this out from a logistical point of view. Let me see what's going on here quickly so that we can, let me just check. Graham, are you still online? I'm going to unmute your mic. Graham, can you hear me?
Yes, I am.
You are there. Would you like?
I can.
Can you see the
question?
Yes, I can hear you loud and clear.
Yes, indeed.
Can you hear me?
Excellent.
Perfect.
Yes, indeed, I can. Thank you, Lisa.
And you can see the question on the screen asking when will regulations will be promulgated. I'm going to hand the mic, well, metaphorically hand the mic over to you if you wanted to answer that question to Lizelle.
I would love to. Thank you, Tertius, for referring, and Lisa for referring the question to me. I would love to be able to throw some light on this. Unfortunately, I can't. I know, as I think everyone else does, that the public participation process has been completed. I know that a lot of comments were received by the Department of Human Settlements. I have not been instructed to go through these and give. So I'm in much the same position that you are. I know that they are receiving attention, at least that is my understanding, but as to the detail, I mean, I, like many of you, attended the public participation meeting that was in Cape Town, and I saw the responses that were given, which indicated that the department and the representatives of the Community Scheme Ombuds Service were taking the comments made by the public very seriously, and there was even indication that certain of them were going to be dealt with. You know, Tertius, you mentioned the question of interest rates and this sort of thing. Certainly, my impression was that the comments made an impression on people, and that one would expect there to be changes. But exactly how that process is going, I wish I could help you with. I don't have any inside information on that. And as to when the Act and the regulations will come into force, I, like everyone else, has a guess, and my guess is that it will be relatively early next year. And my guess is based on the fact that the CSOS exists. It's a fairly big organization at the moment, and that people will do what is necessary to get its engine started. So when I look at, I know exactly what has to happen. I know the processes, as I'm sure all of you do. But in essence, my guess is that we should be looking at round about April. This can be derailed, of course, but that would be my best guess. Would be that we would start seeing the actual operation in round about April next year. Lisa, would you give it back to Tertius at this stage? Hello?
Oh, sorry, Graham. Can you hear me now? I was chatting to myself there for a while. What I'm going to do, Graham, thank you very much for your answers. I am going to hand it back over to Tertius. Lizelle, Tertius is going to address the rest of your questions. Anita Vermeulen, we do have your questions as well, which Tertius has taken a look at. He says they're very specific to the conduct rules of your scheme, so he will address you personally on that. I have forwarded your emails on to him, but we're going to go on to the next question that we have from Lizelle, which is the time for comments on the draft regulations have closed. Do you have access to the comments? Will any of those be made public? And I would love to see the comments that have been submitted. I'm going to hand over to Tertius to answer you on that.
Thank you. Thanks, Lisa, and thank you, Lizelle, for the questions. Just to revert to Graham's comment before, which I didn't hear, my own estimation is that the Act and the new regulations will come into force about March, April next year. Now, the time for the comments have closed. Do you have access to the comments? It is, will any of those be made public? I would love to see the comments and that have been submitted. No, I personally do not have that, and I doubt it very strongly whether they will be made public for understandable reasons. I don't think everybody would want everybody to see what their comments were. My views on the interaction, that's question number 3, on the interaction between the new Sectional Title Management Act and the Community Service Ombuds Act. Of course, there's a very close relationship between the two, And in fact, the one can't work without the other. For instance, when you look at the rule situation, the Ombuds service will, as I said, receive all rule amendments and file them and actually examine them for approval. So the relationship is very close. The function of the Ombuds service is not only to manage disputes, but various other things, and that is unfortunately why bodies corporate will also have to pay for that service. Fourth question, I understand the Ombud has been appointed. That's correct. There's also been a regional Ombud appointed in Cape Town. I do not know how the infrastructure is progressing. I believe that the infrastructure is very well in place, but what I'm concerned about, of course, is the training of staff. I don't know how far that is developed. Fifth question, implementation of the new Act and regulations, including new management and conduct rules. What will the status of the old rules be? Well, first of course, all new schemes will automatically, as the prescribed rules, adopt the new rules, unless they make their own rules. As far as the importation of the new rules into existing schemes is concerned, I also think my view is that where the scheme has the prescribed rules in place, without any amendments, those rules will be replaced by the new prescribed rules. Where the body corporate has made its own rules, those rules will stand as far as it's compatible with the new management rules. That is how I see the situation. Of course, I've given you a simple answer to a difficult question, but we'll see how that works out in practice. Any more questions, Lisa?
Tertius, thanks very much for the answers. Lizelle, I hope those answer your questions. I'm sure if you've got anything further, you're more than welcome to send them through to Tertius directly. If there's anybody who has any particular questions right now that you would like to ask based on what Tertius has given us, and I found it I've learned a few things this afternoon as well. Please do just type your questions in now. What I will do is I will unmute your microphone if you have a question that you would like to ask for everybody to hear. Now is the opportunity while we're all still glued to the screens and listening. Is there anybody at the moment? What I'll do is I hope there's not going to be too much noise disturbance, but I will unmute microphones if there's anyone who would like to ask a question. I think what we should just all do is just try and be as respectful as possible and just give everybody an opportunity to speak one at a time. You're welcome to press the little hand icon. Who's that? Sorry, was there someone there who wants to ask a question? Can you guys all still hear me?
Hello, can you hear me?
Yes, Alex? I can. Yes, hi, Alex. Alex, what is your question?
My question is just on this last point, on point 5.
On point 5, okay.
Yes, as far as amended. We amended the Rule 40 to make provision for the financial statements to be signed off by an accounting officer.
Sorry. Okay.
All we did,
hello, just repeat that.
Are you still there? Are you still there? Hello,
I'm
can I
here
speak?
now.
Yeah, okay.
That's what the union should do. I don't have any invoice as far as I know that the body corporate Neil would have attended.
Hello?
Hello, I'm here. The two people talking.
Okay, it's Alex. Can I proceed?
Yes, Alex, go ahead.
Well, that's it. Then she mustn't. Then she, she's not prepared to accept.
Just a moment, Alex. There's somebody else talking at the same time.
It's an easy thing. If
Just a moment,
even if it's leaking in a sectional title, if it's leaking from the exterior, the body corporate is obliged to repair it. If it's leaking from another, that's what I'm explaining. These agents are stupid, man. They don't understand. And if it's leaking from another flat, then the other flat is obliged to attend to the repair.
Hello?
Hi, yes, Alex. I think everyone wants to ask. I think if everyone wants to ask a question, the same time, guys. We have a question from Alex that if everyone's
That is-
speaking at the same time, what I've done is I've unmuted everyone's mics, which I think is going to be a much smarter idea for you to mute rather. Let's do that. There we go. So now I've unmuted everyone's mics. Alex, I'm going to give you the floor. You had a question that you'd like to ask. I've actually muted everyone else because I think there's too much noise disturbance. So I'm going to hand you over to Tasha. Sorry for the inconvenience. And just please ask your question through to Tasha. Just give us a second.
Thank you. I'll be quick. We amended Rule 40. We just changed the reference where it says to if a complex, if there are more than 10 units. All we just amended there was to make it if the complex has less than 17 units, because we happen to be 16 units, just so that an accounting officer can sign off the financial statement. Now, in hindsight, it seems as if it would have been better to rather substitute the rule with a completely new worded rule rather than just to amend the figure, because I'm just wondering how that would now affect the situation with the new rules, if you follow what I'm getting at.
Well, no. I think that would be regarded as a proper amendment of your rule, and that rule, special rule of yours, will probably stand, or it should, in my view, it should stand. So
Yes.
Your special rule should remain with that small amendment of the number only.
Okay, thank you very much. This is
Okay, pleasure.
thank you.
Perfect. Alex, I hope Tasha was able to assist you on that. We have perfect. I'm going to turn over now to Karin Kutsia. Karin's question comes through: what does the new Act and regulations say about Schedule 1 and 2 rules? So, Karin, what I'm going to do, let me just make sure that I've got, there's two Karins here. Let me just make sure Karin is, okay, Karin we seem to have lost you online, but I'm going to hand the question over. Tasha, do you want to address that question now, or perhaps in a newsletter at the end of the month, with regards to what does the Act and regulation say about Schedule 1 and 2 rules? Is that a simple, quick, easy answer, or something you want to address at a later stage? Okay, perfect. Hold on a second.
Okay, this question is whether what is going to happen to Schedule 1 and 2 rules. Now, Schedule 1 and 2 rules are the rules that were prescribed under the old 1971 Sectional Titles Act, and those rules have been substituted by the new, call it new, 1986 Act rules in any event, unless they've been amended before the 1986 Act rules, Schedules 8 and 9 came into operation. So I'm not exactly sure what you mean by, but in as far as the Schedule 1 and 2 rules have not been amended, they will certainly be replaced by the new rules under the new 2011 legislation. And again, as in the previous instance, the amendments that could have been brought about of the Schedule 1 and 2 rules, any amendments would stay in place if it's compatible with the management rules, the new management rules. I hope that answers the question.
Stay on the line, Tasha.
Okay, I'm staying on the line.
I'm going to move closer to you.
Okay.
We have a question that has come in from Tinus.
Tinus
Bam. Tinus's question says, why does it state in the e-course that the auditors must...
Why does it state
in the e-course that the auditors must confirm whether rules have been submitted? Is this a function of the auditors, and where does it stipulate this in the rules?
Yeah, it does stipulate it in the rules that the auditor must certify, as part of their report, must certify that any amendments to the rules have been filed. It does say so. That's all I can say about it. You'll find it in the management rules.
Okay, I should see if there are any other questions. We've got plenty of questions.
There are a lot more questions apparently.
Yes. Let's try and take this one. I think we can always address these at a later stage, but we have one here that says, how much would you charge a complex to examine their rules? That's a private question. I'm sure you can address that.
Okay, this is a private question. How much would I charge a complex to examine their rules? Well, we have a special going at the moment, right at the moment, in fact, that we are prepared to audit the rules at 1,500 Rand plus VAT per set of rules, or also if it's a homeowner association, the constitution of that association. That will just be an audit. It won't be a revision of the rules. It will just be an audit to say this rule does not achieve its objective, or this rule is illegal, or it should rather be changed this way, etc. But it will audit. It will be a proper audit, and it will be also done very quickly. So you can contact me at tertius@section.co.za if you want your rules to be audited in that way.
Let's have a look at what other questions we've got that's come through. Okay, so we've answered, are house rules enforceable? Can a house rule override the rule or a section of the Act?
No, I think I've answered that question already. Can a house rule override a provision of the Act or the rules? Of course not. The house rules are not allowed. There is no such thing as house rules, so it can't override any of those provisions, of those legal provisions. Next.
Okay, let's have a look at the next question. Let's have a look, see. Okay, that's just, yes, today is being recorded, so it will be available to everyone. You might just not tell them that.
Yeah, this has been recorded and it's going to be available to everyone that's interested.
Karen has a question. It says, do you think rules that restrict short-term letting are reasonable?
Yeah, this is a very difficult one. Whether a rule that restricts short-term letting is reasonable and enforceable. We've dealt with that quite a few times already, and the principle is, of course, that to impose a rule like that at a later stage is very difficult, because an owner can argue that at the time that he or she bought, there was no such rule, and now that rule is being enforced against them. And I think that would be a good argument. So you have to be very sure that if you import a rule like that, that all the current owners are actually in agreement. In other words, it's going to be preferable to put that into your management rules and obtain a unanimous resolution.
Okay. We have another question here from Nico Carstens.
Nico Carstens, how's the music going?
I think it's Arno Carstens.
Arno Carstens,
yes,
okay.
No, this is Nico Carstens. Nico says, here, Tertius, you mentioned that one can amend CR4 to allow trustees to approve the enclosing of a balcony.
Yes.
Why in the same CR4 amended rule can you not say that the person who encloses the balcony must also maintain the improvement?
Well, in fact, you can, and that's what we usually do. Okay, I don't know whether you heard the question. Do they see the questions?
I don't think they do, Mr. Welcome. There it is.
Okay, the question is...
I'll just speak into the mic for you. There we go.
Okay.
It says, you said that you can amend CR4 to allow trustees to approve the enclosing of a balcony. Why in that same CR4 amended rule can you not say that the person who encloses the balcony must also maintain the improvement? That is a question that's come through from Nico Carstens.
Okay, yes, and in fact we do that. When we draft that rule or that amendment to Rule 4, we usually put that in also, that the owner of the section must then maintain that particular enclosure. It's a bit unfair to have other owners have to pay for that, because when you enclose a balcony, of course, you're creating new common property. The outside of that would be common property, and if something goes wrong with it, the body corp will have to bear at least 50% of the cost of that. So it's very reasonable then to make the rule so that the owner will be responsible for the cost of maintenance. In fact, provision is made for that in Section 37(1)(b) of the Sectional Titles Act, that you can make a rule like that.
I'm going to unmute Karen Melissa Derman. I see Karen has a number of questions. Karen, I'm going to hand over to you. You should be able to, Tertius should be able to hear you now if you want to ask your questions. I see you've got quite a couple of questions here for Tertius. Yeah.
Hello? Hello?
Hi there. It's
Yes, hello Karen.
How are you?
No, she's disappeared now.
She disappeared, okay. I think what we'll do is I'll tell everybody if you'll address this question later.
Yeah, okay.
Yeah, Karen, I see are you there? I think we may have lost you. Your question hasn't come through. Can you hear me, Karen?
Hi.
Yes.
Absolutely, I can hear you.
Oh, perfect. Yes, you're coming through loud and clear. I'm going to hand the microphone over to Tasha. I see you've got a number of questions, and I see we're running a little bit short on time as well. But what you can do is maybe pick one or two of your questions for Tasha's, and the rest I will print out for him to address to you personally, and in his newsletter as well, and perhaps even on his website a little bit later. We will post all the questions that have come through. But I see you've got quite a few, and I see you are listening quite attentively, and I'm sure you're waiting for an answer. Perhaps you want to just mention the question on, is there a conflict of interest in CSOS, or any of your other questions that you'd like Tasha's to address. So I'm going to hand you over to Tasha's, and hopefully your questions come through loud and clear, but we can hear you. Hold on a second.
Okay, I'm here. Your first question?
Okay, hi, Tasha. My first question is, what do you think, do you think that there will be a conflict of interest where the CSOS has to adjudicate on an issue that's relating to rules that it itself has approved?
Yes, there could be a conflict of interest. You're quite right. But of course, it should never happen. It should never happen that there's a conflict of interest, because if they have approved the rules, then that rules are in place and is enforceable. Their role then would be to, as far as enforcement is concerned, is to whether somebody has breached the rules or not. So I don't think that it's likely that there will be a conflict of interest. No.
Okay, thank you for that. And then also, you spoke about PAJA applying to body corporate decisions or actions when it came to fining rule.
Yeah.
Can you possibly clarify, is it your opinion that PAJA does apply to bodies corporate?
PAJA?
Their actions or their decisions? Yes.
Yes, that is why I said so. PAJA does apply to bodies corporate, to their administrative actions. And fining somebody is an administrative action in terms of PAJA. So yes, PAJA does apply.
Okay, I did go quite deeply into PAJA when I was writing my thesis, and I did a lot of research and went into administrative law. And what I did seem to conclude, which I'm open to discussing, maybe not in detail now, but is that PAJA really only applies to public decisions and only to private decisions when there's a public function. So maybe it's a bit of an academic discussion we can have at another time. Maybe go to another question. But lastly, do you think that an exclusive use rule contained in the conduct rules creates an adequate right to exclusive use, or do you think it's an insecure right?
Do I think it's a what right?
Do you think it creates an adequate right, an exclusive use rule that's contained in the conduct rules that's made by special resolution, or do you think it's better for exclusive use rules to be contained in management rules?
Oh, yes. Well, I can tell you that it's been widely practiced to create your exclusive use areas, section 27A, in the conduct rules. I've done that myself many times. And in fact, the new legislation allows that specifically. So I don't think there's a problem with doing it in the conduct rules. One must remember that exclusive use rights in terms of section 27A are not real rights, they're personal rights. So I don't see that there is any disadvantage of putting them into the conduct rules.
I suppose really the only thing that I can think about is that it's made and can be changed by a special resolution.
Yes, that's true.
Where in the management rules it can only be altered or changed or exchanged by your resolution.
Yes,
maybe it just gives a more secure right.
That is so.
It's just a thought.
Yeah.
Absolutely. Thank you so much for answering my questions.
Pleasure.
And thank you for the webinar. It's wonderful.
Karen, thanks very much. Guys, we've definitely run out of over time today. So what I'm going to do is all your questions that have come through, we have noted them, and I'm going to pass them on to Tasha's when we are done so that we can address each and everyone's questions. I'm sorry if we weren't able to address your question right now, but we will definitely address it at later this afternoon or very latest tomorrow. And I'm sure what we can also do, perhaps, Tasha's, when you and I have a little bit more time, perhaps next week, is do a webinar with all these questions, sort of like a Q&A across the table. We'll have a chat, and we'll be able to post that for everybody to be able to view as well. So from my side, from a very, very hot, sweltering Stellenbosch outside, and from Tertius, thank you very much for your time and for lending us your expertise again. And to everybody, Graham as well, for answering a question that we've passed over to you. I'm sure that both experts in your fields, your views and your opinions are most definitely valued, and we all wait with bated breath to see what the Sectional Title Amendments Act, when it comes into absolute force and comes into play next year, early next year, first quarter, we'll see, and how that's going to affect the industry. But in terms of the rules that we've chatted, what that Tash has chatted about today, and all the questions that we have, we just want to say thank you very much. We have had an overwhelming response of questions, of people that have attended and registered, and there is going to be a short survey at the end of this webinar, about 5 or so questions that you can just answer. Let us know whether you found it informative. It's simply clicking yes or no, and whether you would like us to do this on a weekly or a monthly basis. You're also welcome to throw topics through to Tasha's or to myself to put together, and we can actually do this on a regular basis. I think it makes it so much easier to be able to listen and tune into a webinar. Just bear in mind, you can make use of the webinars. You don't have to sit at a desk. If you have a relatively decent smartphone like everyone else does these days, you can actually tune in while driving, put your earpiece in, so it makes it very user-friendly and convenient. If you've got any questions on webinars, you're welcome to address them through to me at Lisa at Stilus, and I will be able to assist you if you've had any technical difficulties or would like to know more. In terms of topics, please do send through to Tertius, and we will definitely be in touch and make these available to you. So we see it's now 1:15. This has probably been the longest webinar that I've definitely hosted. Tertius has got plenty to say, and I'm sure all of you have many more questions. But for now, we're going to say over and out, and hope everyone enjoys the rest of what's left of Thursday and the weekend coming up. So thanks very much to everybody. We'll be in touch soon.